Assistant Chief Bender, we're live, you can start.
Hello, I'm Assistant Chief Andrew Bender of the Palo Alto Police Department, and welcome to the third in a series of 4 community briefings that the department has been putting on over the course of the month of July. It is our goal to provide the community with key information on several components of how the Palo Alto Police Department serves and operates in our community. And it is my hope that through these community briefings, the community will be better informed about what we do and how we serve the community. With that said, let's get started. The topics for our community briefing today will focus on laws of arrest and search and seizure. But before we get started and get into our presentation, just a quick note. Due to a previous technical issue, this presentation is being re-recorded and not being broadcasted live. However, we still encourage you to leave comments and questions down below. As previously stated, one of our goals for these community briefings is to deliver a presentation and provide specific information on a specific topic given to our students in our basic and advanced Citizens Police Academy. And that's what you're going to get a sense of here. Any questions, comments resulting from this presentation will inform further conversations planned in the coming weeks at our Human Relations Commission and other discussions in the planning stages. Lastly, if you haven't had a chance to attend our basic Citizens Police Academy, I encourage you to consider participating in one of these sessions the next time the department offers it. So let's get started. In and of themselves, each of the topics that we're going to cover today could be discussed at length for well over the hour time limit that we have allotted. What are we going to talk about today? We're going to discuss constitutional protections and the role of the police, consensual encounters, detentions, and arrests. What are the differences between these 3 contacts with the police? We're going to talk about the lawful authority to conduct search and seizure of people and property. And then lastly, we're going to discuss probation and parole. Now, please keep in mind that today's community briefing will touch on some selected relevant points for each topic of discussion. But I do encourage that any of you that find a particular topic of interest that you do your own research to find out more. So our first topic of discussion will be about the constitutional protections and the role of the police. How do the police and the Constitution work together in our community? Let's start with a really basic foundation. What is a constitution? Constitution is a written document defining the basic laws of a nation or state. It defines powers and duties of the government, and it guarantees certain rights to the public. Now, the U.S. Constitution was effective in March 1789. And if you remember from your time back in school, the first 10 amendments were called the Bill of Rights. In 1850, California became the 31st state and adopted its own constitution in 1879. Now, police officers in the city of Palo Alto follow both the U.S. and the California constitutions. So, why is the relationship between Constitution and the police so important? The U.S. and California constitutions provide officers with an immense amount of power, and with that, police officers have a legal, moral, and ethical responsibility to protect the rights afforded by the U.S. and California constitutions. Now, these constitutions, they provide our officers with the authority to arrest and to deprive a person of their freedom. Americans place a very high value on their personal freedom, and any misuse of arrest authority by officers undermines the relationship and the trust between the police and the communities they serve. It's also important to point out that the California and the U.S. constitutions, they restrict an officer's authority in certain situations, which we'll talk about in a bit as part of this presentation. But for now, let's talk about two key amendments. Let's start with the Fourth Amendment to the U.S. Constitution. And as I previously mentioned, this is part of the first 10 amendments or the Bill of Rights to the U.S. Constitution. The Fourth Amendment provides that people, houses, and effects, which are your belongings, shall be secured from unreasonable searches and seizures, and it requires probable cause for the issuance of warrants. The Fourth Amendment is set up to avoid unlimited actions by the government and to protect a person's privacy, liberty, and possessions. And it's very important to note that the police have a responsibility to protect the Fourth Amendment rights of all citizens. Why is that important? We need to work within the limitations and restrictions to ensure a free and democratic society. The next amendment I'd like to talk about is the 14th Amendment to the U.S. Constitution. The due process and equal protection clauses of this amendment apply to portions of the Bill of Rights to all states. Why is this important to the police? Well, it requires police officers to apply the law equally to all people, to treat all people the same regardless of their race, creed, nationality, religious preference, or national origin. It also ensures that everyone is entitled to equal protection, even our community members who are here and undocumented. So now that we've touched a little bit and laid the foundation of how the Constitution and the police work together, let's talk about laws of arrest. We will discuss consensual encounters, detentions, and arrests. Now, you may be wondering, what differentiates each of these types of contacts when engaging with the police? Well, let's talk about each one individually. First type of contact that we'll talk about are consensual encounters. Now, consensual encounters between police officers and community members are very common. And it's likely you've spoken with an officer in your neighborhood or out in public about an issue concerning your neighborhood or happenings within your neighborhood or city. A common consensual contact I've had over the years is being approached and asked to settle a vehicle code or a driving debate between spouses or family members. I can tell you that those have to be handled with the utmost neutrality. But let's get back to a consensual encounter. What is it? A consensual encounter is a contact or conversation with a police officer that doesn't involve police commands, force, lights or the use of lights or sirens. Now, in order for, if an officer would like to engage in a consensual encounter with a community member, the officer doesn't need any level of justification. That's because a consensual encounter is not considered a Fourth Amendment seizure of a person. So that means an officer can go have a conversation or contact any person that they would like. Now, on the flip side of that, as a community member or the person who's engaging in this consensual encounter with the officer, it's important to remember that you do not have an obligation to answer the officer's questions, provide identification, or continue the contact. Now that we have an understanding of what constitutes a consensual contact, let's talk about detentions. A detention, or a temporary detention or stop, is an assertion of authority by a peace officer that would cause a reasonable person to believe they are not free to leave. And so you can already see the difference between a consensual encounter and a detention, in that a detention is an assertion of that authority by a police officer in which the person believes they are not free to leave. Remember, that was not a component of our consensual encounter. So What would make a person believe they are not free to leave? Could be physical restraint by the officer. It could be the use of the officer's red light on their police vehicle. It could be unequivocal verbal commands such as, "You are being detained and not free to leave," or other conduct by the officer such as blocking your ability to leave. Let's also talk about some real life examples. It might be that you were driving and you ran a red light, or you committed a violation of the vehicle code, and there's a police officer that sees you and gets behind you and puts on the red light and siren and pulls you over. That's a traffic stop. That would be an example of a detention where the officer is exerting some assertion of their authority and you do not feel that you are free to leave. Another example might be a subject that's possibly involved in a crime. So if an officer was out on patrol and heard a broadcast of a person to be out on the lookout for because they were involved in some type of crime that had just occurred, and this person that the officer sees matches a description and potentially has other information which leads the officer to believe that they are involved in this crime, that officer has the right to conduct a detention of this person. Now, it's important to note that detentions are limited in scope and intensity and duration, meaning that the officer can only do certain things and it can only last for a certain amount of time. We'll get into that in just a bit. But as you're seeing here, a detention is more than a consensual encounter, but as we'll get to in a little bit, it is less than arrest. It's somewhere right in between. Now, one of the ways that an officer, or the means through which an officer can assert their authority and ensure that the person believes they are not free to leave, is the officer needs to ensure that they have developed what we call reasonable suspicion. So a lawful detention requires reasonable suspicion of criminal activity. So unlike a consensual encounter where an officer can go and speak with or contact any person they wish, for a detention, officers have to have an articulable reason or factual basis for lawfully detaining a person. So you may be asking yourself, what is reasonable suspicion? Well, let's talk about that on the next slide. Reasonable suspicion is enough facts and circumstances to make it reasonable to suspect two things. One, that criminal activity is occurring, and that the person that the officer detained is connected to that criminal activity. Now, reasonable suspicion may be based on the totality of the circumstances, meaning everything going on, everything known to the officer, kind of like a collective puzzle that the officer's putting together. And it can be based on a number of things, some of which might be observations by the officer, personal training experience of the officer, and eyewitness information that the officer may have received from witnesses, victims, or other people associated with the event. Now, it's very important to know that an officer in developing their reasonable suspicion, that it not be developed or based on a hunch or instinct. It has to be more than that. Also, there are many factors which could be considered contributing factors for establishing reasonable suspicion. As I mentioned earlier, I equate it to pieces of a puzzle adding to the totality of the circumstances for an officer in which they base their decision on. And when an officer is forming their reasonable suspicion, they can account it on multiple factors, meaning they can use more than one thing. For example, an officer may observe someone that is part of a be on the lookout for in public and matches that description, while at the same time being told by a victim or a witness, hey officer, that's the person who's involved in this incident. That's how those things come together. Now, some additional factors which might be considered for an officer in developing the reasonable suspicion: the person's appearance or condition. Are they intoxicated? As I've mentioned before, do they resemble a known wanted person? It could be their driving behaviors, their demeanor, the time of day, or the location of the stop. These are just some of the factors that an officer can use to articulate their reasonable suspicion based on the totality of the circumstances. Now, as I had mentioned on a previous slide, officers are restricted in what they can do during a detention to ensure that the detention does not turn into an illegal arrest. So let's talk about some of the investigative actions that the officers can take during a detention. Part of these restrictions include questioning the person about their conduct, contacting other individuals to confirm explanations, verify identifications, or conduct records check. During a detention, an example of that would be during a detention, an officer may want to conduct a records check to see if the person is wanted, to see if they're named in a restraining order that might be involved in the incident, to see if they're on probation or parole, or any other information that the officer might be able to learn about this person. They can also check premises, contact neighbors, and can also reach out to businesses that might be able to provide information about the incident and the reason for the stop. Now, as I mentioned earlier, detentions must be timely, and detentions must not last any longer than is necessary to resolve the reason for the stop. So once the reason for the suspicion has decreased or disappeared, the officer must release that person. So an example might be a person detained for a crime is not being involved. And let me see if I can give you even a more better example of that. If a person comes home and they come home to their house being burglarized, and they can see that person burglarizing their house run out the back door, and they're able to get a quick look at them, and they call 911, and the police working patrol respond to the area, and a description is able to be put out, and that officer stops someone that they believe and they can articulate matches the description of this person that was observed by the homeowner. If at some point during this detention, the homeowner is able to get to the officer's location and do what we call an infield and takes a look at this person being detained, but is able to relay to the officer that this person is not the person that they saw run out of that house, that person needs to be released immediately if the officer has no other reason or reasonable suspicion to prolong that detention. Now, it is important to note that during a detention, officers can take appropriate investigative actions that are reasonable under the circumstances to determine a subject's possible participation in the criminal activity being investigated. So during this detention and during this time that is reasonable, the officer should be working to confirm or dispel their suspicion about what this person's involvement is in that criminal activity. Let's also talk about search and seizure during a detention. Cursory or pat searches are allowed during detentions to protect officers from assault. Now, officers just can't do them on their own for their own reasons. They have to be able to articulate specific facts which cause them to reasonably believe the person is carrying a weapon or a dangerous instrument. And it's important to note that the scope of such a search, these cursory or pat searches, is limited. The cursory or pat search must occur on the outer clothing of the person to locate possible weapons. This is not a search for an officer to try and find evidence or contraband. Again, this is the purpose of cursory or pat search during a detention is done to protect the officers from assault, not go on an expedition for evidence or contraband. Now, if the officer discovers an object that they believe to be a weapon or dangerous instrument that can be used as a weapon, the officer does have a right to remove it. But also, once the officer realizes an object is not a weapon or an object that can be used as a weapon, the officer cannot further manipulate that weapon. Now, also consider these types of searches, a cursory or pat search, should happen in limited circumstances where the officer is able to articulate specific facts and certainly do not happen on every police contact. Now, what are some factors that support reasonable suspicion that a person is carrying a weapon or pose a danger to that officer? It could be that the officer sees a bulge in the person's clothing, or it could be that the reason for the detention is associated with a crime that involved the use of a weapon. Let's also talk about force and the use of force by an officer or restraint during a detention. So what force can an officer use during a detention? Well, if a person attempts to leave during a detention, officers may use reasonable force and/or physical restraint to compel the person to remain. What does reasonable force include? It could include handcuffing or the placement of the subject in the back of a police vehicle. If the officer does choose to use this amount of reasonable force, the officer should be ready to articulate why they needed to handcuff or place the individual in the back of their police vehicle. Now, an officer's use of force under these circumstances doesn't necessarily elevate a detention to an arrest, but that force that the officer used must be used in accordance with California Penal Code 835A. And just as a reminder, in a previous community briefing, session number 2, Acting Captain James Reichschneider presented use of force, and I encourage you to go back and watch a recording of this briefing for more information on this topic. So, now that we've covered consensual arrests and detentions and the differences between those two, let's talk about arrests. What is an arrest? Arrest is the taking of a person into custody in a case and manner as authorized by law, and that's covered under California Penal Code 834. Now, it's important to note that an arrest is a full seizure of a person under the Fourth Amendment because it takes away from that person's liberties, takes away their freedom. Now, if you remember, the criteria for a detention was reasonable suspicion. Now, the criteria for any arrest is that any arrest that an officer makes must be based on probable cause. And any arrest made without probable cause infringes on a person's privacy protected by the Fourth Amendment. Now, let's make a couple important distinctions. As I mentioned, the difference between arrest and detention is custody. It implies a full control of the subject by the officer. And also, as I mentioned, I apologize, earlier with detentions, we talked about reasonable suspicion, but now with making arrests, we're going to talk about probable cause. What's the difference between the two? Well, probable cause is a higher standard of suspicion than reasonable suspicion. But it is important to note that factors that an officer uses to contribute to the reasonable suspicion can also be used to establish probable cause for arrest. The officer can also use the reasonable suspicion factors to escalate and developing that probable cause to make an arrest of a person. So what is probable cause? Let's talk about it. Probable cause is a set of facts that would cause a person of ordinary care and prudence to entertain an honest and strong belief that the person to be arrested is guilty of a crime. Now, much like a detention, probable cause is based on the totality of the circumstances and may include, but is not limited to, direct investigation or reports, meaning information that the officer has received directly from either victims or witnesses or persons associated with that incident, circumstantial evidence, secondhand statements from reliable sources, and a police officer's expertise. Now, just backing up a bit, notice in the first paragraph there, it has the words honest and strong belief. It doesn't say indisputable, doesn't say 100% certain. Probable cause does provide some leeway for officers making the determination that the person is guilty of a crime. What it says is it's facts that would cause a person of ordinary care and prudence to entertain an honest and strong belief that that person is being arrested as guilty of a crime. Now, jumping down to this last bullet point, I want to talk about a police officer's expertise. Over the course of a career, police officers can become well-versed in specific fields of law enforcement. It might be narcotics, stolen vehicles, robbery, burglary, or other property crimes. And during the course of working these types of specific crimes, they develop the ability and the expertise over time to identify activity which might otherwise appear innocent can actually add to a set of facts that they use in developing a probable cause for an arrest. So let's talk about elements of a lawful arrest. California Penal Code 836 establishes the legal basis for an arrest by a police officer. There are two circumstances that an officer can make an arrest: pursuant to a warrant and without a warrant. Let's talk about elements of a lawful arrest pursuant to a warrant. Officers must establish probable cause for a warrant through a sworn statement, which we call an affidavit. Then an arrest warrant is issued, which is a written order signed by a magistrate, which directs and commands a police officer to arrest the person named in the warrant for the offense named in the warrant. Now, let's discuss warrantless arrests next. So first, let's discuss warrantless felony arrests. A warrantless felony arrest can be made whenever the officer has probable cause to believe the person to be arrested has committed a felony in the officer's presence, meaning the officer observes the person committing that crime in front of them. Number two, committed a felony although not in the officer's presence. And this might be a circumstances where the officer is present at the scene, hears something happen, and then observes that person associated with maybe that crime, an assault with a deadly weapon, and is able to develop a probable cause that a felony has just been committed, and maybe they heard it. And then the third criteria, or the third reason an arrest, a warrantless felony arrest can be made, would be committed a felony regardless of whether or not the felony was in fact committed. And this one can be a little bit tricky to understand, and I'll do my best to give you an example. It could be that the officer makes a contact out in the field, and during a search of a subject, he finds a substance which that officer believes to be a controlled substance. It looks like a controlled substance. It's got the texture of a controlled substance. It's packaged like a controlled substance. And maybe even the subject tells the officer this is a controlled substance that this person was possessing or trying to sell. But then ultimately, so the officer makes that arrest, that felony arrest, but ultimately that substance is sent to a lab. And during when the lab looks at this substance, they determine it is not a controlled substance. It is not a legal substance. Well, the officer, based on the totality of the circumstances, did have the probable cause to believe at that time that the person had committed a felony. Now, a question that you may be wondering is, are there restrictions when officers are allowed to make warrantless felony arrests? The answer to that is warrantless felony arrests can take place at any time of day or night and on any day of the week. You're going to see that's a bit different from warrantless misdemeanor arrests, which we'll get into next. So let's talk about warrantless misdemeanor arrests. A warrantless misdemeanor arrest can be made whenever the officer has probable cause to believe the person to be arrested has committed a misdemeanor in the officer's presence. So this is similar to a warrantless felony arrest, meaning that the person to be arrested committed that offense right in front of the officer, and the officer was able to observe that. or not committed a misdemeanor in the officer's presence, but the crime involves specific circumstances as defined by law. And let's talk about those circumstances. They include a misdemeanor committed by a juvenile, driving while under the influence, carrying a loaded firearm on an individual's person or in a vehicle on any public place or on any public street, violating a domestic, protective, or restraining order when the officer was responding to a call alleging the same, committing an assault or battery on a spouse, cohabitant, or parent of their child, committing an assault or battery on school property while school is in session, committing an assault or battery against a working firefighter, emergency medical technician, or mobile intensive care paramedic, and lastly, carrying a concealed firearm at an airport. Now, as we just discussed about when officers can make felony warrantless arrests, let's talk about when officers can make a warrantless misdemeanor arrest. Officers can make warrantless misdemeanor arrests between the hours of 6 a.m. to 10 p.m. unless one of the criteria is met. The crime is committed in the officer's presence, the person is arrested in a public place, or the subject is already in custody pursuant to another lawful arrest. Now let's talk about use of force or restraint during an arrest. If you watched last week's community briefing on use of force, you'll recall that the California Penal Code authorizes police officers to use force that is reasonable and necessary to make an arrest, prevent escape, or overcome resistance. The force that is allowed by the California Penal Code is used to accomplish taking a subject into custody. Remember, that's the key element that distinguishes a detention from an arrest. Now we're going to transition into our third topic of this community briefing, and that's search and seizures. And we're going to talk about conducting search and seizures of people and property. So what does the Constitution say about protections against unreasonable search and seizure? Let's take a look. Article 1, Section 13 of the California Constitution states, the right of people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches shall not be violated, and a warrant may not be issued except on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the person and things to be seized. So what are some of the key terms and concepts here? Well, number one, people have a right to be secure against unreasonable seizures and searches. Two, warrants can only be issued based on probable cause supported by oath or affirmation. Remember, that's the affidavit. And place, person, and things to be searched are specific. So, when does a search occur? Well, according to the Fourth Amendment and the California Constitution, a search occurs when an expectation of privacy that society is prepared to consider reasonable is infringed upon the government. In this case, and for purposes of our community briefing, that would be law enforcement. Now, it is important to note that the Fourth Amendment and the California Constitution do not give an absolute right to privacy, nor do they prohibit all searches. They limit searches that are considered unreasonable by the courts. So if an officer can search when it's considered reasonable, what does that mean? Well, when the courts look at whether a search is reasonable, the courts will look at the totality of the circumstances and then balance the individual's right to privacy against the government's, in our case law enforcement's, need to gather evidence and apprehend criminals. And in determining reasonableness, the courts consider the officer's probable cause to search. What does it say and how does it measure up? So how does an officer establish probable cause, or what is an officer's probable cause to search? It's enough facts or information to provide a fair probability or substantial chance the item sought will be located in the place to be searched. So it's specific facts articulated in court or sworn statement that show that there's a fair probability to believe a crime has occurred or is about to occur, evidence pertaining to that crime exists, and evidence is at the location the officer wishes to search. Now, it's less than absolute or even a near certainty, but more than a mere hunch or suspicion. Some of the key terms to consider here are fair probability and substantial chance. These are important because they mean the officer can develop sufficient facts to articulate the probable cause to conduct a search, but end up not locating the items to be sought when the search is actually conducted. Now, keep in mind, not finding the items to be sought during a search does not in and of itself make that search unlawful. So let's talk about warrantless searches and seizures. Warrantless searches of private property are presumptively illegal. This is a good premise to start from. But under certain conditions, officers may lawfully search and seize evidence without a search warrant. These are the exceptions to the warrant requirement, and they're listed below, and we're going to discuss each one. Plain view, cursory or pat search, which we've already touched on, consent search, exigent circumstances, incident to arrest, and probation and parole searches. So what these exceptions means that if the officer is going to conduct a warrantless search, it must fall under a specific exception allowable by law. Let's talk about these exceptions a little bit more. The first exception that we'll talk about is plain view. Plain view, in order for the officer to conduct a plain view search, warrantless search, the officer needs probable cause that the item is contraband or evidence of a crime. The officer also needs to have a lawful right to be in the location where they're conducting this plain view search, and the officer needs to have lawful access to the item. Now, it's important to note that officers are not expected to blind themselves to what they see in plain view if what they see can be associated with crime or criminal behavior simply because they don't have a warrant. Also, for consideration, the owner or possessor of an item has no reasonable expectation of privacy for items that are in plain view for all to see. The next warrantless search we'll talk about is cursory or pat search. If you remember from when we discussed our detention, we discussed this type of search. Now, in order for a cursory or pat search to occur during a detention, the officer needs to have a lawful intention for investigatory purposes. Also, the officer needs to be able to articulate specific facts for why they believe that that person may be carrying a weapon. And remember, the purpose of this search is done on the outer clothing and only meant for the purposes of determining whether that subject being detained has a weapon that could injure or assault the officer. This is not just a free search for the officer to determine what's in a person's pockets or in what they're carrying on their person. Now, also, once that officer determines through this cursory or pat search that the object is not a weapon, that officer needs to move on from this search. So let's talk about warrantless consent searches. In order for a consent search to be valid, the officer needs to obtain that consent from the subject that they're searching voluntarily, and it also needs to be obtained from a person with authority, meaning that that person who gives the consent for the officers to search needs to have control over that object, house, or vehicle that they're authorizing for the officer to search. Now, in considering the lawfulness of a consent search, Voluntary consent means that it's an act of free will and not the result of duress or coercion on the part of the officer. The person who's giving that consent truly needs to feel and believe that they are doing it of their own free will and not for any other factors or influence from the officer. The next warrantless search we'll talk about is exigent circumstances. Now, exigent circumstances are emergency situations that require swift actions on the part of officers to prevent imminent danger to life or safety, serious damage to property, imminent escape of a suspect, or the imminent destruction or removal of evidence. Now, under this exception, the primary purpose of the officer's entry or search is to attend to the emergency situation. So once inside a residence, the police officer may do whatever is necessary to resolve that emergency, but once that emergency has been dissipated, a warrant may be needed for any further searching. Let's now transition to warrantless searches incident to arrest. Warrantless searches incident to arrest must be done in conjunction with a lawful arrest, the person being in custody, and also the search must be contemporaneous to this arrest. Now, what does custody mean and what is a custodial arrest? A custodial arrest is one in which the subject will be transported to another location or facility, such as a jail, a detox center, or the police department. Now that we've talked about consensual encounters, detentions, and arrests, let's move on to our next topic for today's community briefing, and let's discuss probation and parole and the search and seizure components that accompany these conditions. Let's first talk about probation searches. Probation is a sentencing alternative for a person convicted of a criminal offense that's granted at a judge's discretion. So, rather than incarceration, the person that is released from jail or incarceration falls under the authority of the probation department. Now, in order to do this, in order to get out of incarceration, probationers consent to certain conditions that could include avoiding drugs and criminal behavior, and or submitting to searches without a warrant, probable cause, or reasonable suspicion. Now, the California Supreme Court has noted that warrantless, suspicionless probation searches are reasonable under the Fourth Amendment. So what does a warrantless, suspicionless probation search entail? Let's take a look at that. Based on a probationer's search conditions, officers are entitled to search in places where objects might be reasonably located. Now, prior to this search, officers do not need to contact the probation officer or receive permission from that probation officer, but officers cannot search or conduct a probation search for purposes of harassment or for arbitrary and capricious reasons. These probation searches must be done for rehabilitative, reformative, or legitimate law enforcement purposes, such as law enforcement believes that the probationer being searched is involved in some type of criminal activity or may be violating the conditions of their probation. Now, if law enforcement does conduct a probation search of a probationer, the searches must be conducted in a reasonable manner and cannot exceed the scope of the search conditions. Now let's talk about some important consideration for probation searches. The first, not every person on probation has a search condition, and the second is not all search conditions are the same for every probationer. Some may be broader than others depending on specific terms of the probationer. It's important to note that officers know these probation conditions before they conduct a probation search of a probationer. Let's talk about parole searches. Parole is a condition of release from state prison which allows an individual to serve a remainder of a sentence outside of prison. Now, all California parolees are subject to warrantless searches by law enforcement. As you remember from the last slide, this differs a bit from probationers in that not all probationers are subject to search and seizures, and probationers may have different components to their search conditions. But for parolees, all California parolees are subject to warrantless searches by law enforcement. That means that random, warrantless, suspicionless parole searches do not infringe on any reasonable expectation of a parolee's privacy. Now, similar to probation searches by law enforcement, any parole search by law enforcement must be done in a reasonable manner and execution and cannot be conducted for the purposes of harassment. Now, to this last bullet point, what might be some factors that contribute to a search being considered harassment? It could be that law enforcement is conducting the search or engaging in a search too often. It could be that the search takes place at an unreasonable hour. It could be that law enforcement unreasonably prolongs the search. Number 4 could be that the officer is doing it in an arbitrary or oppressive manner. Or it could be that the search is undertaken with personal animosity towards the parolee by law enforcement. Okay, well, this will conclude our 3rd community briefing, and I hope you've enjoyed the presentation and learned something new. In closing, I'd like to encourage you to tune into tomorrow's community briefing on accountability within the Palo Alto Police Department, which will be presented by Acting Captain James Reichschneider. Again, that community briefing will be Wednesday, July 22nd at 2 p.m. live on Zoom and YouTube. Now, in preparation for this community briefing, I encourage you to visit the links on the slide that you're seeing now to learn more about the Palo Alto Police Department and its accountability.